Welcome to our discussion on impeachment techniques in evidence law. Impeachment is fundamentally the process of attacking the credibility of a witness who has testified. When we impeach a witness, our primary goal is not necessarily to prove that the substantive facts asserted in their prior statement are true, but rather to show the jury that the witness is unreliable, mistaken, or untruthful on the stand today. Under the Federal Rules of Evidence, specifically Rule 607, any party, including the party that called the witness, may attack the witness's credibility. One of the most common and powerful methods for achieving this is through the use of prior inconsistent statements, often abbreviated as PIS. These are statements made by the witness previously that contradict what they are currently testifying to in court. This chapter introduces this concept and sets the stage for examining the specific rules, such as those found in Rule 613, that govern exactly how and when these prior statements can be introduced and used during trial. We established that impeachment primarily targets credibility. Now, we must draw a critical line: the difference between using a prior statement for impeachment purposes versus using it as substantive evidence. When used for impeachment, the prior statement is admitted only to show the witness is unreliable or untruthful today. The jury is instructed to consider it only for that limited purpose, not for the truth of what was said back then. However, there are limited exceptions where a prior inconsistent statement can be admitted for its truth, that is, as substantive evidence. The most significant exception arises under Federal Rule of Evidence 801 Subdivision 1, Clause A. This rule allows a prior inconsistent statement to be admitted substantively if the declarant testifies at the current trial and is subject to cross-examination concerning the statement. If these conditions are met, the statement is not hearsay and can be used to prove the facts asserted in that prior statement, fundamentally changing its evidentiary weight. While we just covered the rare instance where a prior statement can be used substantively, the vast majority of impeachment scenarios rely on Federal Rule of Evidence 613, which governs prior inconsistent statements generally. For a statement to qualify as a prior inconsistent statement under Rule 613, the prior statement must genuinely contradict the witness's current testimony given on the stand. This contradiction is the linchpin. However, not every slight deviation opens the door for impeachment. The inconsistency must be meaningful. A minor variance in detail, such as recalling a time difference of 5 minutes instead of 10, usually will not suffice on its own. Similarly, a mere omission in the prior statement is generally insufficient unless that omission fundamentally alters or negates the meaning of the testimony given today. The prior statement must truly suggest the witness is now being untruthful or mistaken about a material point. Now that we have established what constitutes a meaningful prior inconsistent statement, we must turn to the critical procedural hurdle required before we can introduce any outside evidence to prove that statement. This is governed by Federal Rule of Evidence 613, subsection A, which mandates laying the foundation. Before the cross-examining attorney can introduce extrinsic evidence, that is, evidence other than the witness's own testimony, to prove the prior statement, they must first confront the witness with that statement. This confrontation requires giving the witness an opportunity to explain or deny the statement they allegedly made previously. This step is absolutely mandatory. If the prior statement was made orally, the attorney must specifically ask the witness about the statement, perhaps reading a portion of it or describing the circumstances, and then allow the witness time to respond. Failing to provide this opportunity generally bars the later introduction of extrinsic evidence to prove the statement, regardless of how contradictory it might be. We just established that confronting the witness is mandatory when the prior inconsistent statement was made orally. However, Federal Rule of Evidence 613 subsection A provides a significant exception when the prior statement is documented in writing. If the prior statement is actually in writing, and critically, if that writing was signed or otherwise adopted by the witness, the procedural landscape shifts. In this specific scenario, the court may permit the introduction of extrinsic evidence to prove the statement, even if the witness flatly denies ever making it. This is a major departure from the oral statement rule where denial usually bars extrinsic proof. Nevertheless, one requirement remains absolute. The cross-examining attorney must still show the writing to the witness during questioning. The witness must see the document, even if they deny authorship or adoption. This ensures fairness by allowing them to confront the physical evidence before the jury hears about it through other means. Now that we have completed the mandatory confrontation phase under Rule 613 subsection A, whether by direct questioning or by showing the writing, we move to the next critical stage if the witness denies making the statement or if the denial is insufficient to satisfy the rule. This stage is governed by Federal Rule of Evidence 613 subsection B, which addresses the use of extrinsic evidence. Extrinsic evidence is simply evidence introduced from a source outside the witness's own testimony on the stand. Think of it as bringing in outside proof. This proof might involve calling another witness who heard the statement, or perhaps introducing a document that memorializes the prior statement, provided the proper foundation has been established. In essence, Rule 613 subsection A deals with the questioning phase, getting the statement on the record and giving the witness a chance to explain. Rule 613 subsection B governs the subsequent proof phase, using external evidence to establish the statement's existence when necessary. Federal Rule of Evidence 613 subsection B dictates the admissibility of this extrinsic proof. Once the foundational requirements of subsection A have been satisfied, meaning the witness was confronted with the statement and given a fair opportunity to explain or deny it, the extrinsic evidence itself becomes admissible for the purpose of impeachment. This admissibility is quite broad, assuming the foundational step was completed. If the witness denies making the statement, or if their explanation is unsatisfactory, the proponent may then introduce the external evidence, such as calling the person who heard the statement or presenting the document. Remember, the primary hurdle for admitting extrinsic evidence is ensuring compliance with the confrontation requirement of Rule 613 subsection A, if that opportunity to explain or deny was provided. The extrinsic evidence is generally allowed to demonstrate the inconsistency to the jury, thereby attacking the witness's credibility. This sets the stage for the next crucial limitation we must discuss, the collateral matters rule. While Federal Rule of Evidence 613 subsection B generally permits the introduction of extrinsic evidence once the foundation is laid, this admissibility is subject to a significant restriction known as the collateral matters rule. This rule dictates that extrinsic evidence is generally inadmissible if the prior inconsistent statement relates only to a collateral matter. So, what exactly is a collateral matter? A collateral matter is defined as a fact that is not relevant to any substantive issue in the case, nor is it relevant to the witness's credibility itself, beyond merely showing they contradicted themselves on that minor point. Think of examples like a witness's favorite color, or extremely minute, irrelevant details about their travel route to the courthouse. If the inconsistency touches only these tangential points, the court will typically exclude the extrinsic proof, even if the foundation under Rule 613 subsection A was perfectly satisfied. The rationale here is judicial efficiency. We do not want to try secondary issues just to impeach a witness on a minor point. We will explore the exceptions to this rule in the next segment. We now turn to the crucial exceptions to the collateral matters rule, which dictate when extrinsic evidence is permitted, even if the inconsistency seems tangential. Extrinsic evidence becomes admissible if the prior inconsistent statement relates directly to a substantive issue central to the case. For instance, if the statement contradicts testimony about who was driving the car in an accident case, that is clearly non-collateral. The second major exception involves statements that bear directly upon the witness's capacity to observe, recall, or, most importantly, their general truthfulness. This category includes prior statements that reveal bias, corruption, or a motive to lie. For example, if the witness previously stated they were paid to testify a certain way, that statement is not collateral because it attacks their core credibility, not just a minor factual detail. In these situations, the policy favoring judicial efficiency yields to the need to fully test the reliability of the testimony on critical matters. To conclude our discussion on impeaching a witness using a prior inconsistent statement supported by extrinsic evidence, let us synthesize the required procedural roadmap. Successfully employing extrinsic proof demands adherence to three critical prerequisites. First, a genuine inconsistency must exist between the witness's current testimony and their prior statement. Second, the proper foundation must have been meticulously laid under Rule 613. This means the witness must have been afforded an opportunity to explain or deny the statement, unless the prior statement was in writing and signed or adopted by the witness. Third, and crucially, the subject matter of the inconsistency cannot be purely collateral. It must relate to a substantive issue or attack the witness's core truthfulness, as we just discussed. Regarding the exceptions to the rule, if these three steps are satisfied, extrinsic evidence is admissible to prove the prior statement. Remember always, even when proven with extrinsic evidence, the statement's purpose remains solely impeachment. It is used to show the witness is unreliable, not to prove the substantive truth of the prior assertion.